The Judiciary Committee will resume our hearing, and the gentlewoman from Texas, Ms. Jackson Lee, is recognized for her questions.
Thank you very much, Mr. Chairman, and I appreciate this hearing. It's been fascinating, and I'm disappointed, not because I don't have two remaining stellar witnesses, but that the Attorney General would not allow me to banter with him. But I hope as we go forward with our witnesses, we'll be able to give all members a chance to question all witnesses and that their time will be accordingly. This is an important issue, and I just want to start with sort of a given constitutional premise from the Wickard-Filburn case that indicates that even when a farmer grew his own wheat for personal consumption, it was discerned that it was interstate commerce. So I want to raise the questions of policy and law, Mr. Bellinger, because you have argued before the Supreme Court, and because we have two distinct positions, four courts, two decisions. One, the Affordable Care Act is constitutional, and then the second with two courts are unconstitutional. And I might make the point that there is certainly some question as to the persuasion of the two courts that rendered the decision that it was unconstitutional. So the Supreme Court becomes even more important. And I think that's what the Founding Fathers intended for us to do. Let me just give you these numbers. 5.8 million Texans without coverage, includes 1.5 million children. My state has the highest rate of residents without health insurance, 26.8%. According to a Gallup poll, 16% of American adults are without health insurance. Census numbers say that 46 million Americans in totality are uninsured, 41.5% Hispanic Americans, and 19.9% of African Americans. Those are policy questions. And let me just ask this, as I reflect on Supreme Court decisions through the ages, or say in the last, since 1954 decision on Brown versus Board of Education, have lawyers made policy arguments before the Supreme Court?
Well, I think the answer to that question is yes. In many instances, lawyers in our system do argue what the practical outcome would be of one decision or another. It is
along with the law, I understand. But
throughout, yes.
But in fact, you can raise sort of the irreparable harm potential from a policy perspective as you make your arguments.
That is one kind of argument that people can and have made, yes.
Well, I would venture to say a state that has some 26% or large numbers of unemployment, 5.8 million, and 26.8%, a nation that has 41% Hispanic uninsured, and then a sizable number of African Americans. I think we have a question of whether there's been irreparable harm. So let me just proceed with some of the questions. I'll ask you, Mr. Bellinger, if instead of the word penalty, someone has said you'll get a ticket if you don't have health insurance, would that have answered some of the opponents' concern? Tickets, you got a parking ticket, you got a lack of health insurance ticket. Are we in the business of semantics? Do we need to say that you have a ticket? You get a ticket when you don't have insurance. Would that have answered this whole question of the mandate?
I think that's...
Are we playing semantics here?
Right. I think that's a question better asked to those who believe it's unconstitutional. I think it's, since it's no more intrusive than Medicare or Medicaid as a practical matter, I don't think the label matters, that it's not constitutional in any respect. Professor Barnett, if they imposed a ticket on you, would it be unconstitutional?
And before he answers the question, let me also raise this question, and I'm not being facetious, but could I not be engaged in economic activity by actively not getting insurance? Isn't it a fine line of semantics? And might I just, let me just put this on the record so then you both can answer this. Just a few years ago, Republicans, Senator Orrin Hatch, supported the idea of mandates in the Republican proposal for health insurance. In fact, as I understand it, he said to tell you what you have to buy, even if you don't want to buy it, is a quote. And then their particular plan would have required everyone to buy coverage and would have helped them do so by giving them a health care credit, which was a point made earlier. So couldn't I actively not be insured, and isn't that economic activity? Professor?
I thought maybe I would add to our conversation a definition of penalty and the definition of tax that's been adopted by the Supreme Court in a 1996 case. And here's how Justice Souter defined those two terms. He said, if the concept of penalty means anything, it means punishment for an unlawful act or omission. So that's what a penalty is, the substance, not the label, just the thing. By contrast, he then described a tax as, quote, a pecuniary burden laid upon individuals or property for the purpose of supporting the government. That's a tax. So it isn't just a matter of labels. It is a matter of substance. And you have to ask yourself, is the penalty that's called a penalty in the bill, is it a punishment for an unlawful act or omission defined as failure to have health insurance, or is it a enactment, a burden laid upon individuals for the purpose of supporting the government?
I'd ask the chairman for 15 seconds, please, just to respond.
The woman is recognized for an additional 30 seconds.
I thank,
Congressman.
I thank the gentleman. And I would make the argument, one, that instead it is an incentive to do right, that it is not penalizing you because penalty is punishment. You're not punished if you have health insurance, in fact. And so you are, in fact, incentivized to have health insurance rather than take the negative, which is to suggest because you have the penalty, you're being punished. I am helping you. I am helping you not have 26% uninsurance in the state of Texas. I'm helping children be insured. I'm helping diverse minorities be insured. And I know during the civil rights arguments, even though we were arguing on the Constitution, there were many policy statements being made. Do we want to live in a nation that discriminates against a person for the color of their skin? In addition to the amendment constitutional arguments, do we want to live in a nation where there are people who are uninsured, cause catastrophic costs to the nation, and others have to pay? I think that is a question that should be considered by the courts. And I also need to, I understand the pseudo language, but I also need to say whether or not it is more a incentive than it is a punishment. I am more inspired by an incentive, and I welcome it being a parking ticket. We give parking tickets all the time, and no one complains about being required to do the right thing. I yield back.
Gentleman's time has expired. The gentleman from South Carolina, Mr. Gowdy, is recognized for his questions.
Thank you, Mr. Chairman. I want to start by commending all three of the witnesses, the two that are remaining, and the Attorney General, for the civility and professionalism with which you disagree with one another, which really is an example for all of us. Professor Dellinger, was Morrison correctly decided?
I'm sorry?
Morrison, was it correctly decided? Yes. So Congress can mandate that the victim of domestic violence purchase health insurance, but cannot set a forum in which she seeks justice for her injuries.
That is correct.
Help a guy that made a C in con law understand.
Well, the reason is that the Supreme Court held in Morrison that local crime had only an attenuated connection to national commerce.
But she's got injuries, which will be treated for at a hospital. So we can make her have health insurance for her injuries,
Correct.
but we can't set the forum for the adjudication of the underlying crime.
Correct.
What about Lopez?
That's because there's something different about the healthcare market, that you can't avoid participating in it and transferring the costs to others. And also, what the court was concerned about in Morrison and in Lopez, regulating guns near schools, was the fact that once you got into the area of local crime, since all local crime affects commerce in the sense that people who are crime victims are less productive, there was no limit to
in
what
Title
Congress could
18,
do.
you specifically have to prove that the gun traveled in interstate commerce. And in Hobbs Act, you have to prove that the good that was stolen from the store in a Hobbs Act case traveled in interstate commerce.
Correct.
So you would concede that this language, Congress shall have the power to regulate commerce among the several states, still means something.
Yes.
Can Congress mandate the purchase of dental insurance if we show that overall dental health is tantamount to overall general health? Can we mandate the purchase of dental insurance?
It would depend on what the Supreme Court said in upholding the
But you
healthcare mandate.
Well, I'm asking you, if you were on the Supreme Court, you are advocating on behalf of the constitutionality of this particular mandate.
If I were on the Supreme Court asked to pass on a mandate to purchase dental insurance, right, I would want to know whether Congress had the same basis for showing that people had no choice but to get dental care, and maybe that showing could be made, and that the cost of that care, when obtained, was transferred to other taxpayers.
What about life insurance? Because we're all going to die, and generational debt's a bad thing. Can Congress mandate the purchase of life insurance?
I would assume that that's distinguishable because there's no showing that if you don't buy life insurance that the cost is going to be imposed on other Americans.
Can you give me 3 examples where you would find that Congress has exceeded that the Commerce Clause is not as elastic as some of my colleagues believe it to be?
Yes.
I'll just take 3.
I'll take 3. Congress cannot regulate that you eat broccoli, that you go to a gym, or in my view, that you purchase a flat screen television.
So you do not see much of a stretch between mandating the purchase of health insurance and mandating other things that contribute to good overall health, like vision insurance and dental insurance.
Contributing to overall health is a fine and salutary objective, but it may be one that the court would think is a matter for local governments. This is a regulation of an economic activity itself. And let me just give you one example.
All right, I'm going to give you 10 seconds because I've got one more chance to ask another law professor a question, and I've never had this chance in my life. So.
Professor Barnett again, and if I have a moment, I'll come back. Go ahead.
All right. Some would argue that you gave the roadmap to the opposition, so to speak, by your wonderful advocacy in Raich. Am I pronouncing it?
Right, Raich. It's Angel Raich was my client.
All right, and that is marijuana being sold and grown purely within a state, and you convinced the Supreme Court that impacts that Congress can regulate that. How is that not a roadmap for the opposition?
When you say I convinced the Supreme Court, you mean I argued strenuously against that, and I only got 3 votes, and I lost that case. So
you lost it. Well, then good. That makes me feel better.
It was Solicitor General Paul Clement who won that case.
All right.
I failed to convince the court.
In 10 seconds, if the chairman would give me 10 seconds, how does Raich not carry the day on this issue?
Because it would be as though Congress had required that my client grow marijuana for medical purposes. What they said is she couldn't grow it, and the majority of the court said she couldn't grow it because growing marijuana, like growing any other good, is an economic activity and therefore is something within Congress's power to reach, economic activity. But they never said or intimated that somehow Congress had the power to make her grow marijuana. That would be a step that no one even imagined until last year was something Congress would ever claim.
The gentleman's time has expired. Good question. Thank you. Mr. Issa, the gentleman from California, is recognized.
Thank you, Mr. Chairman. The line of questioning has been interesting. I apologize. I've been going in and out with another committee. But I'm trying to understand something. Mr. Barnett, maybe, or Professor, maybe you can help me. There is a long history of states requiring insurance if you want to drive an automobile, right? But even when they require you to do that, I'm a native of Ohio, they've held in those states that constitutionally they can't make you buy the insurance, but they can make you provide the equivalent of insurance. So in the case of Ohio, they can't make you buy insurance. They can make you post a bond, show financial ability to pay if you're in an accident, or buy insurance. Is there anything in the Health Care Reform Act that is the equivalent of that for people who say, I can take care of my own health care?
Well, there is an exemption in the Act for people who have religious objections. So it's somehow not necessary that they...
But being wealthy enough to pay for your own health care is not a religion?
No, no.
Okay, so we don't, in this Act, if there were no other problem, we failed to observe people's right to pay out of their pocket. In other words, we forced them to enter into a commercial relationship with a for-profit entity, an insurance company.
That's the mandate, yes.
Is that enough to be unconstitutional just because we didn't leave them their individual liberty to simply pay the doctor themselves?
I think the way to simplify this, just for purpose of understanding, whichever side of this you're on, is that when you choose to engage in voluntary activity, government at the state and federal level may regulate that activity that you choose to engage in a variety of ways. And the federal government has some powers to regulate, state governments have other powers to regulate, but there's just no dispute that if you voluntarily decide to engage in activity, the government can tell you how to do it. Like, if you're going to drive a car, you got to do it this way. You got to get a driver's license, too, in addition to insurance. That's something else you have to get.
So would you agree that
choose
the
to
federal
do it.
government could simply nationalize all insurance and take away from all states the right to regulate insurance companies, eliminate 50 state insurance commissioners?
The Supreme Court in 1944 said that insurance was commerce, and interstate commerce, and that's the precedent that we're living with. That for 100 years before that, it denied that's true. But now that's established law, and no one's contesting that. So Congress can do, in regulating that industry, whatever they can do in regulating any other industry.
So here's a question I find amazing, and it's not on the same topic as others. So those who voted for Obamacare, we'll call those the other side of the aisle and nobody on this side of the aisle, they could have simply created 50-state complete over-the-border selling, and they could have even taken it on to a 50-state common federalized system if they'd wanted to. They could have usurped all of the states and had anyone who's licensed anywhere be licensed to the federal government and therefore sell insurance in all 50 states, and created incredible competition on a national basis by having a single standard, couldn't they?
The reason why states still regulate insurance is because Congress passed the McCarran-Ferguson Act in 1944 after the Supreme Court said it was in your hands. Then Congress turned around and said, we're going to preserve the state system that had been up and running.
But Obamacare has partially preempted it. It could have preempted that. So I want to understand that when my colleagues on the other side of the aisle said they wanted to bend the health curve down, they wanted to save money, and they wanted to find ways to make things have more competition so that you wouldn't have just one choice in Alabama or South Carolina. They could have done that very easily because one law trumps the one before it. They would simply amend that.
Yes, Congress.
So we didn't do the constitutional common 50-state insurance. We didn't put in any kind of a personal responsibility alternative where you simply post a bond or provide the proof that you can pay for it. We didn't do a lot of things we could do, but we chose to mandate that you pay if you don't pay. Is that right?
Yes, Congressman.
Okay. Mr. Dillinger, you've done a wonderful job of telling me how, there's all these things that are okay constitutionally, but what about that mandate that I pay a private entity rather than, if you will, the personal responsibility that was envisioned by our founders? They certainly did expect that George Washington could have a doctor come in on his own, that he wouldn't have to buy something that wasn't even available at the time, insurance, right?
Right.
Okay. Mr. Chairman, I thank you for this hearing. Being last on my side, I would assume that all that could be said had already been said, but I found one little piece that I thought hadn't, and I yield back.
Thank you, Mr. Issa, for your contribution. Actually, you're next to last because the gentlewoman from Florida, Ms. Adams, is recognized for her.
Oh, I'm sorry, only on my side. Thank you.
Thank you, Mr. Chairman, and I'll preface this by saying I come from Florida also, and I stood with our Attorney General, then Attorney General McCollum, when he challenged this law when it was signed into law. I agree with him. I believe that it is unconstitutional, and I'll go ahead and tell you up front. I'm trying to reconcile how you believe, Mr. Dillinger, that if someone is sitting in their home and they are not engaged in any activity, how the federal government could then force them to engage in this activity?
Well, the federal government, like the state and local governments, has for more than 200 years sometimes imposed affirmative obligations on individuals where they've had power. Sometimes it's an important power like the militia power, where everyone was required sitting at home to go out and buy a knapsack for their ammunition. The Congress in 1792. Congress is never considered quote, regulating inactivity when they impose an affirmative obligation, and they can only impose an affirmative obligation where they already have the power to do so. Now, the penalty in this law does not apply to someone who's just sitting at home. It's only when that person goes into the national economy and earns $18,000 for a couple that they're required to file a federal income tax and make a 2.5% additional penalty payment if they haven't maintained minimum insurance coverage. Like they have to pay a couple of percentage points for Medicare coverage for when they're over 65. They have to pay 7.5% for Social Security for old age assistance after they're 65. Those are impositions that the government makes, the latter two under the taxing power, but none of them seem particularly extraordinary in terms of an incursion in liberty. And in fact, what's sort of
Well,
odd
let
about
me
I'm
stop
sorry,
there,
yeah,
because
let me-
you know, the knapsack and the gun. I also am a staunch supporter of the Second Amendment, and I understand that that was done so that we would have some kind of protection to our country, and that is a constitutional requirement that government provide for our safety and well-being. On that same inference that you're saying, so this person who works may not have a car, and so therefore, under that same analogy, there are car accidents, there are a lot of tort actions, there's a lot of cost associated with those accidents. Would you then say that we should maybe say that everyone, no matter if they own a car or not, because you argued about car insurance, so are you now saying that everyone who owns a car, whether they own a car or not, should have to pay a car insurance so that everyone would be covered if something were to happen in an accident?
No, I would not.
Okay. You made a comment that kind of concerned me. You said that no one can decide not to use health care. Do you believe that everyone has to use health care?
No. What I mean by that, it's a good question. What I mean by that is, except for those who have religious objections to health care, and they are...
You didn't say that, though. You said no one, and you said it right here in this hearing, and I wrote it down verbatim because I thought that was unusual. You said no one can decide not to use it.
Yes, that is correct.
And so that concerns me also, because when I hear about the federal government taking more and more liberty away from the American people or imposing their will on the American people, when I heard that statement, it made me concerned that you believe that no one can decide not to use health care in America.
That is correct. That is a statement of fact, Ms. Adams, not a statement of preference. That is to say, no one can be assured, if you're riding a bicycle like as I do, that you're not going to be hit by a truck and wind up in the emergency room. And when you do, under the Emergency Medical Treatment Act, they're going to have to provide you with treatment, whether or not you're going to pay for it.
If you're hit by the truck, hopefully they have insurance, because if you're driving that vehicle on a state roadway or a city roadway or a county roadway, then, or a federal roadway, in order to have the privilege of driving that truck, you have to have insurance. So let's move on.
I was on a bicycle.
You know where I'm
I would agree
from.
with you.
I really am concerned about that statement, but I'm going to move on because
Congressman, I do not want to.
There's been conversation about choice here, and I would like to know from you and Mr. Barnett, how do you equate choice with mandate? How do you bring those two together?
I bring them together in the following sense, that one proposal for dealing with health care for the last 40 years, one that Congress did not adopt, is simply to extend Medicare from age 65 all the way down, so that people would be taxed out of their income
Can you go quickly?
to pay for Medicare. This alternative, adopted instead, Ms. Adams, gave people more choice among private providers rather than having them limited to a government provider.
Mr. Barnett, quickly.
This bill does give people the choice between a congressionally mandated, between providers of congressionally mandated health insurance policies. You'd no longer have a choice. The insurance companies no longer have a choice on what terms to offer you, and you no longer have a choice on whether to do business with them. The only choice you have is which insurance company you do business with. And that's not really, that is a choice, but it's not the choices that we started with.
Thank you.
I thank the gentlewoman. The gentleman from Arkansas, Mr. Griffin, is recognized for his questions.
I don't have any at this time.
Okay, that makes it easy. We have concluded our hearing. Let me thank the witnesses again for their testimony, and without objection, all members will have 5 legislative days to submit additional questions for the witnesses, and we will make their responses part of the record. Also, without objection, members will have 5 legislative days to submit additional materials for the record. With that, again, thanks to the witnesses, we are adjourned.
Thank you, Mr. Chairman.